Hi guys, it's Kathy. I hope you're doing well. We made it to Saturday. Took me a second, but then it hit me. So, I have a I have a new guest coming today to my home. It's crazy. I don't speak to my mom hardly ever, ever. And late last night, she sent me a text. Hey, some lady I work with just got evicted and lost everything. She has the clothes on her back. That's it. That's what she has right now. So can she just stay with you for a week? Now, every single person in here knows it's not going to be 1 week. But I don't know anything about her. I said, is she a felon? Do I have to hide all my stuff? No, she said, no, she's not a felon. So, later today, someone else is going to learn the joys of living with a gamer who screams a lot. I hope when she leaves, she takes a cat. Maybe she'll take a cat with her. We're down. We got rid of a lot of the female cats. We still have a couple left, but that means we got rid of a lot of chances that we're going to get more cats. But maybe she'll take 2 cats with her. Maybe I'll tell her, you can stay as long as you take 1 cat per week. So if you're here 4 weeks, 4 cats have got to go with you. She does. She does say that about my sister. You're not lying. You are not lying. But she works like 2 blocks away from me. This poor lady works like 2 blocks away from me. And I think she works at like a Staples, like Office Max Staples. She works at Staples and makes like $10 an hour. Been there 25 years. Not full-time work either. And that's her only job. So it's not easy for her to just get an apartment, get a place to lay down and go to sleep at night. But she could still take a cat when she leaves. That's all I'm thinking. I'm using her to take a cat. Anybody else in here want a cat? We got cats. We're getting there. We're getting rid of them slowly but surely. They just snowballed so quickly. It's like we had 4 cats, and then all of a sudden there were just so many. And I'm getting them in, and I'm getting them spayed and neuters, but that's expensive. So I can only do 1 at a time. Alright, where are we? Okay. I know what we're going to do today. We're going to do this guy for a few. So I think we have half of 1 case. I missed the very beginning. And then we have the whole thing of the second one, which is really good. I won't say more. And then we're going to go to Judge Crawford, or Caulfield, or Crawfield, or Crawford. One day I'm going to get it. Maybe if people start typing his name in chat, I'll get it, but I don't know. We're going to finish out with him. I know we've been doing him a lot. We won't do him tomorrow or the next day. How's that? Because he's not streaming today. Saturday. It's either feast or famine with Georgia. In Georgia, there's either nobody streaming or everybody and their mom is streaming. Yeah, she's gonna have to buy her own groceries. Yeah, she's an adult. She can live. You can't just take. You can't, Jude. We've tried for a shelter for the shelter to find these cats homes months. I'm on the waiting list for months. To have the shelter help me rehome. Our shelters are no kill, so they take the animals and they keep them until they find a forever home, and then they'll accept more. And even that's expensive. You gotta pay for her food. For her food, Kelly. She has to figure out her own food. Thank you. Look, Maria. Look, she has to figure out her own food. She's an adult. She can figure out her food. She's an adult. She got evicted, but she still knows she has to eat every day. I've been evicted before. I still paid for my food. I can prove that. I'm still here. All right. Let's get started. Desperately looking for a play button. There he is.
The lawyers are going to have to jump in this thing or get out of it. I mean, I'm not going to do this again, is what I'm trying to say. Lawyers don't need permission from the court to file something. They know what to do. They know how to do it. And they don't have to go through all of the hoops that a private individual has to see a lawyer or to see a judge about getting a TPO. They can file it on their own. But in any event, that's another story for another day. I'm just going to be watching very closely, and we're going to get back to playing by the rules, and we're getting a little fast and loose with what is permitted and what's not permitted. But I'm just giving everybody fair notice. I'm watching any of these cases very, very closely because I am keenly aware that tensions are extremely high. And I'm not going to get in the middle and get shot at by both sides. You're going to follow the rules. We're going to do it by the book, or we're not going to do it at all. All right, well, I'm going to dismiss both of these two cases for the reasons stated. You're all free to go. Thank you very much.
Thank you, Judge.
Sounds like we missed some fireworks. Maria, thank you for the gift sub on Twitch. Thank you so much. So, if you don't know, guys, if you have Amazon Prime, you can get a free subscription to a Twitch channel. So if you do that over on Twitch, you can get
Okay, now I think I
no
have,
ads.
well, I did have it, another Dodge County case. Yeah, I do. Miller versus Miller.
Yes, everyone is here. They're in the back.
They're in the back.
My
Oh, are
coffee's
the
here.
attorneys here? Mr. Harrington?
Be right back.
They are. Okay.
Get
All
my
right. Very
coffee.
good. They know what to do when they get ready. Good morning.
Good morning. May I approach?
Oh, absolutely. I didn't even realize child support was here, so you got everybody handled?
Real quiet.
Okay. I usually announce that, but I didn't this time. Maybe I need to start doing it that way. Seemed to work out pretty good. You holding down the fort back there this morning?
Brian. Ron has a deposition in Atlanta, so I'm holding down the Cochran office today. Mm-hmm.
All right, there you go. Anything else?
Nope. Thank you.
Have a good day. Thank you very much. All right, there's Mr. Harrington. All right, I'm going to take up some of these pro se cases now. All right, first up, I'm going to do Jonathan Byram and Michelle McIntosh, come on up. One of them come over here, and one of them come over here.
I got some coffee. I got
Sit
some
in front of that
coffee.
microphone.
Thank you, Kelly.
Okay.
All right, give me just a minute here. Let me see what I have. Byram versus McIntosh. All right.
Thank you, Monica. Thanks for the cheers, guys. Thank you, thank you. That new thingy works. Yes, it does. I'm going to change the font.
All right, this is case number 2025V0125-CMJ. You are Jonathan Byram,
Yes, sir.
and you are Michelle McIntosh.
Yes, sir.
All right, well, good morning to you both. This matter appears on my calendar today, on our motion calendar, to get some idea of where this case is headed, how it's progressing. I'll note for the record that I have in front of me here the pro se petition filed by Mr. Byram for legitimation, custody, and/or visitation. My calendar indicates that Ms. McIntosh filed some sort of an answer, and that you were served on July 9th, Ms. McIntosh, and filed an answer and you state in your answer, Ms. McIntosh, that you agree to everything in the petition except the change of the name. Is that correct?
Yes, sir.
All right. Well, maybe you're not too far apart, but there's 3 or 4 issues that I'm going to need to get some feedback from the two of you. First of all, you two are not married, never were married. Is that correct?
No, sir.
No.
All right. Well, Ms. McIntosh, the first question is for you. Do you agree and stipulate and confirm that, in fact, the plaintiff or petitioner, Jonathan Byram, is, in fact, the biological father of this child?
Yes, sir.
All right. And do you hereby consent to the legitimation? Is that correct?
Yes, sir.
All right. Now, Mr. Byram, I think I remember seeing in here that you made some sort of request about a DNA. Do you confirm and acknowledge and agree that you are, in fact, the father of this child?
Yes, Your Honor.
Very well. The legitimation is agreed to, stipulated, and ordered by the court. Mr. Byram, you indicate in your petition that you just want to be the father of this child and be able to visit the child. Are you requesting physical custody of the child?
Yes, Your Honor. I want to be able to have joint custody, so therefore I can be able to.
Hold on. There's 2 parts to that. One is physical custody, primary physical custody, and then there's legal custody. They're 2 distinct issues. I presume the child's living with you, Ms. McIntosh?
Yes, sir.
And don't give me the name because this is a public hearing, but how old is the child?
She'll be 8 months old on Friday.
How?
She'll be 8 months old on Friday.
Oh, 8 months old, a baby. Okay.
So young.
Well, Mr. Byram, are you telling me you agree that the child needs to be in the primary physical custody of the mother?
As far as There's been times that I've been trying to see my daughter and trying to be there involved. And one minute it's, I'm allowed to be involved, and then the next minute it's like I get completely blocked out of my child's
Well,
life.
I'll come back to that, but again, that's not what I asked you. You want to have visitation with the child on a schedule, is that correct?
Yes, sir, Your Honor.
All right, and do you have any problem with that, Ms. McIntosh?
No, sir.
All right. I think these are, well, I don't know if these are exactly our standard forms, but Mr. Byram, I don't see it here. We, being the 8th Judicial District, we have pretty much a standard sheet. Do you have access to that? Can you find that for me on the 8th District website? Oh, here it is. It's here. I'm sorry. I missed it. There is a visitation schedule that is included in the petition. Ms. McIntosh, have you had a chance to review this?
No, sir, I have not.
Well, you absolutely positively have a right to represent yourself in these type cases. The problem becomes when there's some disagreement or if the court feels something different needs to be done. And I'm just going to tell you, for an 8-month-old baby, I'm not approving this schedule. All right. It's a lot more complicated than that, Mr. Byram. Mr. Byram, are you married?
Yes, I'm currently married.
Do you have another child?
No, I don't.
This is your only child?
This is my only child.
Never had a child before?
I never had a child before, but I'm currently going through a divorce. I haven't filed for a divorce.
And Mr. Byram, the other issue you mentioned was essentially legal custody. Now, that's the other part of the custody coin, and legal custody, joint legal custody means that you do get, exactly as you phrased it, you get to participate in, medical decisions and when the child gets older, school and other things, all sorts of things. That's usually a part of the deal. The hang-up usually comes down to the issue we just described, physical custody, visitation, and the third topic is child support. I don't think you made any reference to child support in your petition, Mr. Byram. What are your thoughts on child support?
Child support, I think if the father should be able to support their child and, be able to make sure their child has what they need.
Oh, I agree, that's the law. But the problem is you didn't say anything about that. Are you telling me, are you employed somewhere?
I have my own business. I work for, I'm the owner of Georgia Southern Lawn Care Pro LLC, and I've currently have worked a few jobs in order to establish my business, and my business is actually doing pretty good.
Well,
I've actually been in business for 5 years with the state of Warner Robins, city of Warner Robins, Georgia.
well, Mr. Byram, I don't want you or anybody to think that I just sit up here and throw a bunch of rocks. There's a lot of work that's got to be done on this file before I can get anywhere remotely close to issuing a final order. Everything that we've talked about has to get resolved either by agreement or by a final hearing. And there are too many things left open for this court to sign a final order today. The visitation issue has to be worked out. You got to have a schedule.
Okay.
You got an 8-month-old baby. None of that is addressed in here. The child support has to be finalized. None of that is addressed in here. I can't act as your lawyer, Mr. Byram. I can't tell you how to do it, and I can't do it for you, and I'm not going to do it for you. It's a lot. Now, I know lawyers are expensive, and I know it's difficult. I understand all that, but I can't approve this as it sits right now. There's too many things that are left dangling. I can't tell you how to resolve it. I can suggest that you hire a lawyer and finish this up. Otherwise, we're just going to be on a never-ending cycle of I'll be bringing you back to court, every couple of months, asking on the status, and I can't tell you how to do it, and I'm not going to tell you how to do it. I got too much to do. So you got two choices, Mr. Byram. You can either figure it out yourself or hire a lawyer.
I think if me and her decide to come together and figure it out together for our child, for
That may
the best
be.
of our child, I think that
That's another
would.
story for another day, and that doesn't concern me. That doesn't involve me at this point. I can't tell the two of you how to resolve this. It's just a lot that's got to be done, and I'm not approving this today. So I'm going to give you 60 days. I'm going to reschedule you. I don't know when that'll be. Have we sent out the 2026 calendar yet? Hadn't got it yet. Okay, well, I don't know when the next court date will be. Of course, we're getting to the end of the year, and we're working on our 2026 calendar now, and it's about 99% done, I think. You'll get a notice in the mail. That's all I can tell you. But I'm going to give you 60 days. You won't hear from me for 60 days, but I'll bring you back, and then unless you hire a lawyer or get it resolved, and then we'll go from there. Any questions?
No,
No,
sir.
Your
All
Honor.
right, that's continued for today. You'll get a notice in the mail. You're both free to go. Thank you very much.
All right.
Well, that is a nice foreshadowing of what's about to occur in this courtroom.
All right, number 5 is Ms. Smith. Come on up. You can come up here to the podium. Is Jackson Douglas Register in the courtroom? Are you come up here to the podium, Ms. Smith? Let's see, that is the wireless. Give that thing a thump. Let's see if it's on. There we go.
There we go.
All right, give me just a moment, Ms. Smith. Just for the record, I see that Mr. Register was served on August the 6th, 2025. He is not present in the courtroom, and I don't see any sort of reply or response from him. All right, you have a child, is that right? Don't give me her name, but how old is she?
So she just turned 17.
17? Oh, okay. Oh, I see it here. Yeah, just a couple weeks ago. And you already have a child support order in place? Is that what I see back here?
Yes, sir.
Oh, you just did this too back in, well, let me see. Oh, gosh, 2011.
Yes, sir. We've
And
been
that's six-
separated that long.
Yeah, Judge Mullis signed this. Good gracious. So this same order's been in place for
Good
14 years?
gracious.
Okay. And it's current, he's paying it every month? Income deduction or something like that?
Yes.
Okay. Wow. All right, well, it is ready to proceed. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give in this case shall be the truth?
Yes,
You put your hand down. You are Marty Lane Smith, is that correct? And you are a resident of Blakely County, Georgia, and have been so for at least 6 months before you filed this complaint, is that correct?
yes, sir.
And it says in here that Mr. Register is a resident of Blakely County, and he was served by the deputy sheriff on or about August the 6th, 2025. I do not see any sort of responsive pleading or answer. Have you received anything from Mr. Register?
No, sir.
It says in here that the two of you were lawfully married on November 26, 1999 in Blakely County, Georgia, and separated in September of 2015 and have remained separated since that time. Is that correct?
Yes, sir.
Is your state of separation permanent?
Yes, sir.
And you have one minor child born of the marriage who will very soon, next year, will age out of this. Is that correct?
Yes, sir.
Is your marriage irretrievably broken?
Yes.
Is there any possibility of reconciliation?
No.
And you have already divided all of your property. You got your stuff, he's got his. All you need from me today is a final divorce. Is that correct?
Yes, sir.
And you're going to have primary physical custody of the child. Is that correct?
Yes.
And since she is as old as she is, I'm not going to order any mandated visitation. I see there's a response from her in here, and I certainly will respect her wishes. She can go see him when she wants to.
Yes, sir.
All right. And the child support order that has been in place for a long time will remain in place.
Is there any way of getting it up, or do I have to go through child support?
You have to go back through child support.
Okay.
No, Judge, raise it, Judge.
Because I have financial evidence saying that he
Yeah,
makes.
well, you got to go
Yeah,
back, go
okay.
back through them.
I was just making sure.
That's right.
Taser.
All right, very good. Now, you didn't, or if you said it, I missed it, but do you wish, you don't want to change your name, or are you going to keep it Smith?
Keep it Smith,
You
yes.
never changed it to start with?
I never
Okay.
changed it.
All right, very good. The divorce is granted, and the relief requested is granted. And I will fill this out first chance I get. You can check back with the clerk's office later today about getting your copy, but that will conclude this matter. You are excused. Good luck to you.
Okay, thank you.
All right, thank you. All right, now Ginger Williams and Preston Williams, come up, please.
How are you?
What Jackson name you said, sir?
I can't hear you. What do you say?
I said you said the Jackson name when I first got here. I couldn't remember what Jackson name said.
I still can't hear you. Come on
It's
up.
showtime, guys. Here we go. Get ready.
Oh, are you Jackson Register?
Jackson Register.
Oh,
What's your
sugar,
name
I'm
again?
a top chat.
I don't think I've called.
I'm
No,
a new.
no. You haven't called it. I just
I'm new at this. Hi, Belle. I didn't see you come in because I was on top chat instead of live chat because it's my first day. And Ardo, it's good to see you. All right, guys, it's time for the main event of this courtroom.
know you said somebody whose last name was Jackson.
Oh, no,
So
I
was-
said
Let's see.
Jackson Register.
Okay.
Yeah. Oh, you good? What are you here for?
Me and my lawyer supposed to be here, Mr. Buford.
Okay. All right, we hadn't got to the criminal cases yet, so early is good, though.
I was at work and I couldn't record the criminal cases. Does that hurt your feelings? Because it hurts my feelings. Don't worry, he's getting it together. We're gonna hear this judge today. Where's Bobby? This clip was for Bobby. Bobby, this clip was for you specifically. Somebody call Bobby. You have plenty of time. The judge is still tinkering around. Apparently, the judge has the other things to do right now. She's mad, guys. She's mad. All right, let's try to bump it. It's a bad idea. It's a bad idea. All right, we're at 25 minutes. Let's just go to 26. All right, let's go to 27. Come on, Judge. I heard breathing.
Are present and seated
Good enough.
at council table. Looking through the docket, it appears that the court set this matter down today for a temporary hearing on Ms. Williams' complaint for change of custody. I see, if I'm reading this all correctly, that we were all here previously back in August. And I don't remember exactly why we didn't have the hearing at that time, but in any event, it doesn't matter now. I entered a order in September that set it down for today, for what's called a temporary hearing, to hear, at least on a temporary basis, whatever it is that Ms. Williams contends is sufficient cause for the court to change custody. Just for the record, let me state a couple of things. If I'm reading this all correctly, Mr. Williams received custody from that juvenile court order back in February. Is that correct, Mr. Williams? Okay, and you have custody pursuant to that order, is that correct?
Yes, I do.
All right, that's what I thought. I know I've looked at this before, but it's been a month or so. So you had a full evidentiary hearing, whoever the judge was heard it all and gave you custody?
Yes, sir. She wasn't even there.
I'm sorry?
She wasn't even there at the last hearing, or at that hearing.
All right, and I think you make reference to that, Ms. Williams, as to why you weren't there. But Ms. Williams, this is a temporary hearing only. It is not a final hearing. You have a right to file what you filed, but my function
like
here
that.
today is to, at least on a temporary basis, to get some idea of what evidence you contend or intend to present in this case to justify the court changing custody. So just give me some idea, Ms. Williams, of what you expect your evidence to be.
I do have a timeline wrote out, but if he'd like to go first, he can.
Well, you're the petitioner, you
Okay,
have to go
well, that's-
first.
that's
but I-
perfectly
but
fine.
Just tell me what you're
Okay.
gonna,
So I do-
briefly describe for me what
I
you're
did
gonna
make
present.
copies for you, yes, and I've been working on this for months, so.
Okay,
When the report was made back in October of 2024, the sheriff report, I have all that in this folder. That's when defects got involved. The school bus driver,
well, now, hold on, oh, wait, sweet, hold on, now, let's just take a breath, let me narrow this down a little bit. I'm not retrying the case back in February. Something, you've got to show me something that has happened since February the 4th, 2025. Because everything that from that day previous has been resolved, and that's called res judicata. That means it's decided, a judge has already decided that, and I'm not reopening that can.
Yeah,
You've got to give me something.
yeah,
since
defects
February.
lied on me, and my rights were violated at that.
No, they didn't. No, they weren't. One thing you can appreciate about this judge, he talks fast. He does not talk slow, Mr. Kelly. He talks fast, and we get there fast. Her rights were violated, guys, at a hearing she never showed up to about custody. She just didn't show up. He's like, I'm gonna sue you for this. Okay, Judge, let him go first. I love this lady, but she's a mess.
Point.
Well, Ms.
And I
Williams-
wasn't there to speak because I had COVID.
Ms. Williams, I don't know how to make it any more plain. I don't care what happened before February 4th.
Okay.
I don't have jurisdiction to hear what happened before February the 4th. You've got to show me something that somebody's bleeding buckets since February the 4th for me to justify changing custody.
I do have where he took the TPO out a week after that happened. He lied at the last court hearing. I do have proof of that with the court transcripts, as well as a doctor's note stating where me and my fiance were at the time. He lied. He said I was harassing his boss, did not have no knowledge of that. And I have it right here if you would like to look at that, Your Honor.
A TPO? You mean a
To
protective
keep me
order?
away from my child. Because I called to make a welfare check because he refused communication. He never communicates. He didn't communicate before the TPO and hasn't, of course, since then.
Where was that filed, Mr. Williams?
Here in Blakely County, Judge Caulfield signed it.
And he's already heard that
Yes. The TPO order.
and didn't change anything? You still have custody?
The TPO is still in effect, and yes, I have custody.
He has a temporary education that's not permanent. The defect, that juvenile judge advised me to file custody to get custody back for him to be in my care. And I have proof of no domestic violence, no drug history on my behalf. I have all my mental evaluation, everything right here.
Well, let me say it another way, Ms. Williams. You have to show me something that indicates essentially that Mr. Williams is now either unfit or that the child is being harmed or is detrimental for the child to remain in his
Oh,
care.
yeah, he has a drug history and a violent history.
Since February the 4th?
No, Your Honor, he has a history of it.
Well, if it's before February the 4th, I'm not going to see it, look at it, or consider it.
This TPO, he lied. That is his character. He lies to get what he wants.
And Judge Kofffel's already ruled
Right
on that.
here. But Judge Koffel didn't even bother listening to it. And I had proof. I didn't even have the doctor's note that day because I had to get it from the doctor because we were in Macon.
That's already been ruled on, Ms. Williams. What else you got?
I have a stable home. I have a job. I'm in college. I mean, I have my mental health history showing stability. The main reason they took him because I was homeless. I didn't have nowhere to go, never have been in my whole life. And I passed all the psych tests, drug tests, and did everything they asked me to do. I wasn't there because I was sick, and I have a doctor's note, and the judge didn't accept my doctor's note back on February the 4th. I have all of this in these folders. And he lives with a married couple. That's why we're not together, because he had an affair. He sure did. And he's still over there with her.
Well, that's not before me today either.
So
Well, Ms. Williams,
I've got stability. I fixed everything.
this matter got filed on June the 17th,
Correct.
and Mr. Williams was served on it on July the 15th. No, I'm sorry. June the 18th, filed an answer on July the 15th. Let me see if I can find that. That's probably,
May I say one more
wait, hold
thing?
on just a second. Let me just do one thing at a time here.
You better have a note from your doctor, Terry. I got a note from my doctor. No doctor's note. I wouldn't need a doctor's note for a custody hearing. I would not need a doctor's note. I would be bleeding all over the courtroom floor if I had to be.
And Mr. Williams filed an answer to your complaint. He filed it on July the 15th.
Yes, I have that right here.
Okay, very good. So the issues are joined.
And he gets a check, Your Honor.
Now, the
It's all
two
about
of
that.
you have every legal right to proceed by yourself, pro se as we call it. And as I've told all of the other pro se litigants here before me, that is absolutely fine for you to proceed that way. But you gotta
We are about to hear the best advice a judge has ever given.
understand a couple of ground rules. I'm not the lawyer for either of you. I cannot tell you what to do, how to do it. I can't even remotely suggest how you proceed on these cases. You got to figure it out or hire a lawyer. And that's as far as I can go with this.
I haven't seen my son since last year.
You have what now?
I haven't seen my son since last year.
Judge, nothing else is working, so guess what I'm gonna try? Guess what I'm gonna whip out of my lady purse? Tears. Here it comes.
Well, all of those issues have already been decided by other courts and other judges, and I have heard nothing here today that will justify the court scrambling any of those.
So he could
Orders.
lie in court and
Hold
do
on.
all
Ms.
this?
Williams, hold on. Let me finish. Wow. But today is not, I don't have the authority to just make a final ruling today, one way or the other. It was noticed for a temporary hearing. I will tell you, Ms. Williams, that for today, I am not going to make any modifications. You have certain time frames that you have to do certain things. And your time is rapidly dissipating, Ms. Williams. I don't have the authority to just enter an order, a final order today, but my temporary order is I'm going to, I'm not going to enter a temporary order. I'm going to deny your request for temporary relief. Ms. Williams, if you want to pursue this case, then you have got to get it in the proper form, in the proper fashion, properly before the court, so the court can make a final ruling. Well,
I have everything. There's not really a whole
well,
lot.
Ms. Williams, you can't just shove a big box of papers up here at me. There's certain rules, evidentiary rules, and again, I can't tell you how to do it. I'm
Can't, this TPO is preventing a lot. Like, I can't even see my child. He only wants him because he gets a SSI check. That's the only
and that's
reason.
another issue.
It's
There's
about the
certain
money.
things,
And I
certain
don't
things
care
that
about
have to
money.
be done, and I'm not going to just reach out and scramble another judge's order. If you want those things changed, there's certain things that you have to do. And you can't just sit in here with me and complain about it. You got to do certain things. I can't tell you how to do it. Now, I'm going to give both of you, like I told the other pro se litigants, I'm going to give you, the law says you're entitled to a certain amount of time to do these things, Miss Williams. And I'm going to caution you that your time is rapidly dissipating. And pretty soon you're going to be out of time. So the next time I bring this case up, we're going to have a final hearing. And Miss Williams, if you don't have it ready then, I'll enter a final order. So that's all I can tell you.
How
You've
can
gotta
I
figure
do
it out or
anything,
hire a
Your
lawyer.
Honor, with the TPO? How am I supposed to see my child with the TPO? That is a block. He did that on purpose for no reason.
That's a very good question. Hire a lawyer. All right, that's it for today. You're both excused.
Look at that advice. Hire a lawyer. Hire a lawyer. She's mad. Ooh, she's mad. Ooh. Ooh. You know what? The best part about that whole hearing was that man didn't say a word. That man did not try to defend her accusations. That man didn't start throwing accusations at her. That man didn't start throwing his paperwork up at the judge. That man sat there, answered one or two of the judge's questions precisely, and just sat there. Good job, sir. You didn't win. You just thoroughly whooped her ass. Now, I will suggest in the future, though, sir, if you really want to win, then you have to push her a little further over the edge. She's already on the edge, and you can do that without getting into too much trouble. Yes, you might get into a little bit of trouble following my next suggestion. But, sir, it's worth it. It's worth it. Next time you're in court with this lady, here's what I want you to do. It's not illegal. It's not 100% immoral, right? Hi, Lisi. I want you to giggle at her the whole time. At least, listen, if you can't pull a giggle out, fine. Maybe you're scared the judge will hear her giggle. At least grin. At least have a shit-eating grin on your face and just keep looking over at her grinning. She won't fall off the edge. She will jump off someone else's edge. That's how far you would push her if you did that. Just keep laughing at her when she says words. The judge might get a little upset with you. A little. But do it anyway. Do it. Do it. Please do it. I feel like going to Georgia so I can sit in that courtroom and giggle when she's talking next. Don't do that. Don't, guys. Don't do that. This would be funny. It would be so good. All right, we're going to go to a habeas now. You know, I said yesterday that I don't think we saw Judge Crawford do a habeas before, but I think that's a lie.
That'll be fine.
All right, we're here, but somebody is not. And it looks like when I was recording this, I got some window popped up, so let me get rid of that. And then somebody's not here, so I think I'm going to fast forward it a bit. There, what window? Yay, Monica! I don't even know how far. I'm going to try 20 minutes.
Was not transcript. I would order the transcript.
Minute and a half, Your Honor. I just need to get something in front of me.
All right, you're 10 minutes late.
Okay, there we are. The attorney is 10 minutes late and the judge is cranky.
I apologize, Your Honor. It was put on my calendar at the wrong time, but that's entirely my fault.
I appreciate that he's 10 minutes late. Here's why. There are a lot of Georgia courtrooms, and I have no idea when they are going to go live. I get a message, boom, went live. Oh my gosh. I drop whatever I'm doing, and I run to the nearest computer, and I try to hit record right away. I can't get the beginning. It's impossible to get the beginning. So when he's 10 minutes late, I have time to get to my computer and hit record. But I'm not always available to drop what I'm doing and run to my computer. So it's usually more like 20 or 30 minutes into a docket that I can finally hit record. So I'm proud of him for being late. Now we get to see this whole habeas. I have no idea how long it is. None. It could be 40 hours. It could be 1 hour. I'm just hoping it's at least 35, 45 minutes.
The court will call again 24-CH-027 Gomez versus the warden. Mr. Bullard, are you ready to proceed on behalf of your client, Mr. Gomez?
I am, Your Honor.
All right, Mr. Daniels, are you ready to proceed on behalf of the warden?
Yes, Your Honor.
Mr. Bullard, if you'll give me a brief outline of the grounds that Mr. Gomez seeks his habeas on, I'd appreciate it.
In brief, Your Honor, the issue in this case is that subsequent to Mr. Gomez's trial and conviction for armed robbery, evidence came to light tending to exculpate him, which his lawyers sought to present at his motion for new trial hearing, but which they, for procedural reasons, could not successfully do. That procedural failure to properly present the exculpatory evidence is what we're assigning error as ineffective assistance of counsel to, and that's why we subpoenaed the lawyers here to testify today and lay the grounds for that.
All right. Do you have witnesses that you're going to call?
I do, sir. There are three here today. I have B.C. Chopra, Raina Nadler, and Eddie Campuzano. I think it may be best if we go ahead and invoke the rule.
All right. I'll swear the witnesses. If your name was called, if you'll raise your right hands for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
I so swear.
I do.
I do.
All right, let the record reflect that all have taken the oath. All right, I'm going to ask that y'all
I'm going to ask that y'all thank Jude. I'm going to ask that y'all thank Jude for those 5 memberships. Jude, you are the bestest. Thank you.
remove yourself
Don't remove yourself
from the
for
screen.
gosh, please.
And who are you going to call first, Mr. Bullard?
Ghost.
I'm going to call Mr. Chopra first, Your Honor. I think he'll be the fastest.
All right. All right, Mr. Shepard.
Your Honor, could I
Go ahead.
unmute and turn the screen off? Your Honor, I just want to clarify, do you want us to just unmute and turn our screen off?
That'll be fine. Is that all right with you, Mr. Bullard?
I think my only concern is that they not be able to hear each other's testimony, so I guess we'll need to do something to get them back on, but I can call or email if as soon as between witnesses, if that's acceptable.
Maybe one more. Keep
All right,
your
that's
options
fine with me. Ma'am, is that all right?
So I guess,
Yes, Your Honor, as long as Mr. Bullard has my cell phone, he can just text me and I will be sitting right here waiting.
Thank you very much. All right.
thank you. All right.
So if you haven't been through these cases before, this stuff that they're about to talk about happened 20 years ago, 10 years ago, 7 years ago. So you're going to hear a whole lot of, I do not remember. You're going to hear, what did you ask him on the stand? When he was on the stand, what did you ask him about the cat? Honestly, I don't remember. I don't even remember if it was me. I don't remember. It's been so long. You're just going to hear that over and over.
Morning, Mr. Chopra. How are you?
Good morning, sir. I'm fine, thank you. How are you?
All right. Would you state and spell your name for the record, please?
My name is Bimal Chopra Jr., Bimalchhoprajr.
Hold on just a minute. My court reporter's trying to get my attention. Yes, ma'am. I'm sorry.
He's not been sworn.
I swore them all.
Oh, you did? Oh, okay,
I
I
did.
missed that, Judge, I'm sorry.
All right, she was concerned I hadn't sworn the witnesses, but I have sworn all of them. All right, go ahead. I'm sorry for the interruption.
Also,
Yes.
sorry, most of the witnesses are probably going to be judges or lawyers. It's possible there's, like prison personnel, but it's more likely you're going to get the old judge that was in his last case on the stand here. Yeah. Raven is going to come in here and tell me I'm blowing her ears out. But she only comes in once every 4 months, so is that better, love? All right. We're not going to see a doggy, though. Oh, that would be so cool. Here we go. Let's call the first judge up. I don't know if it's going to be a judge.
Fine. Sorry about that, Mr. Chopra. Name, I assume, can I ask if the court reporter got that part? Or?
Yeah.
Oh, good. All right, Mr. Chopra, are you a barred lawyer in the state of Georgia?
Yes, sir, 1994.
And could you give us a brief snapshot of your practice since 1994?
So I've been in private practice for 30 years since 1995. The first 10 years I did a general practice, country lawyer kind of thing, domestic, criminal, civil of any nature. If it came in the door, we took it. Since time, I've done exclusively criminal defense. I do not have a specialty within the criminal sphere, from murder to jaywalking.
And in the course of your practice, did you come to represent the petitioner, Marco Gomez?
Yes, sir. He hired me.
Do you recall about how long ago that was?
No, sir. I apologize. I received your subpoena and I've not.
Yeah.
My notes don't go back that far.
No, I understand. I say if the record reflected that it was a 2009 indictment, do you have a sense of how long before the trial that you might have been retained?
I recollect being with Mr. Gomez for the entire process. So prior to trial, a minimum of 3 months. I was able to have numerous conversations with him, as well as obtain the discovery in a timely manner, do some follow-up investigation.
And I'll say, Mr. Gomez, Mr. Chopra, what I want to get here from you is really background on the case and your impressions of it. So I'm just.
Yes, sir.
So could you tell the court, or advise the court what the nature of the original case was, and just what the nature of the original case was, and the sort of what you understood the state's evidence to be, to the best of your recollection?
Yes, sir. I understood it to be that a victim and his family, I believe they lived in a mobile home in the Marietta city limits. The victim had borrowed some money from another gentleman and horrifically been the subject of an armed robbery on 2 separate occasions. He borrowed money, that money was stolen. He borrowed money, that money was stolen. The allegation, I believe, and I truly apologize, Your Honor, if I get any of this wrong, but I believe 3 masked men approached the trailer. There were descriptions of the men, height, certain tattoos, types of weapons, not with great specificity, but types of weapons. They forced entry into the trailer of the case in chief, threatened everyone therein. There were children present that gave the most descriptive identifications and made off with the money. I don't believe that anyone was physically harmed. I'm certain they were emotionally harmed. There was testimony to that effect. The most credible evidence that came out at trial and in the multiple police reports was from the children because they had been raised in the United States and spoke English, whereas the victim and his wife were immigrants that I don't believe spoke any English. Telling were descriptive marks on one of the weapons in particular. There was some allegation of essentially an orange, like hunting orange spray paint on one of the weapons. I cannot remember, and I apologize, if it was a shotgun or a crossbow, but it was particularly vivid. Equally vivid, however, were the physical descriptions that one of the young ladies gave. All the men were wearing masks, but it did not cover above their nose. She was able to identify a perpetrator that held a firearm or weapon with the orange paint, I believe, as having a teardrop tattoo or some other type of distinctive marking on their person or on their body. At trial, she testified to the same. However, Mr. Gomez did not have that identifying mark, nor did he match the height or complexion. I believe she said it was a dark-skinned male that was holding that particular firearm.
All right. So is that sort of going, it gets us toward what we were, where I was going with this. Oh, could you tell us what Mr. Gomez's defense was at trial, how you pursued his defense?
So the firearm in question with the orange spray painting was distinctive. There was a photograph, I believe, of Mr. Gomez standing with his father and other family members. Pardon me. In that photograph, the same weapon was being held up just as you would in any hunting photo. And that particular firearm was actually found in the closet in the home where Mr. Gomez resided with his wife, children, father, and other extended family members. And the point at trial was the identification of the individual brandishing that firearm was not Mr. Gomez. Mr. Gomez, particular dimensions, height, weight, skin tone, were not identified by any of the victims that had a lucid recollection. I focused on the fact that this appeared to be gang-related. Mr. Gomez was not in a gang. It appeared to have some relevance to the man that was loaning the money, potentially telling whomever that they could go get it from this family because they would have had this large sum of money. On the eve of trial, I recall distinctly standing in the hallway, and Mr. Gomez's wife indicated to me, my Spanish is incomplete. I believe she did not speak English, but indicating to me that her brother was actually the culprit. And then I was placed on a cell phone call with an individual that was purportedly her brother who admitted doing this crime, but he was in Mexico. This information came at the 11th hour. I had no way to either confirm or corroborate or put that individual under subpoena. One of the co-defendants to this case, I believe, had previously accepted responsibility. Now, if I'm saying that incorrectly, I truly apologize, Your Honor. I'm getting old.
And Mr. Cho, it's helpful, and I know that I expect Mr. Daniels will introduce the trial transcript. So if there are any variances, we can go there. But it's the general approach to the defense and what you did that I'm interested in.
Thank you. The link between my client and the other co-defendant, I believe there were two, but the other co-defendant that was there was that they were friendly or that they had a relationship, a knowledge of one another. It was not that they were comrades, brothers in arms, related by blood or marriage, anything like that. And that once I was able to establish, I believe the co-defendant was actually very friendly with this brother-in-law, purportedly in Mexico, who had just gotten through telling me that he had done it. Now, it was my impression, unfortunately, that either the wife or Mr. Gomez, for some code of silence, I don't know. It was my impression, however, that this information wasn't shared with me in a more timely manner, perhaps to protect them or because they thought that I was such a stellar attorney, I was going to pull the rabbit out of a hat. I don't really know. But as a professional, and I love my job and I take it very seriously, I certainly felt some of the wind going out of my sails because this was Cobb County in the 2000s, and the jurors were extremely conservative, which is a privilege to work in a jurisdiction like that. But with the horrifying allegations of this family being victimized twice in a extremely scary manner, and my client having been identified because of the weapon in the closet, that the police had gotten information that had something to do with it, and then it was matched, so to speak, by the victim's statements and ultimate testimony. I was certainly not carrying a gun with enough bullets.
I understand. All right, so Mr. Chopra, prior to that phone call with the brother of Mr. Gomez's wife, did you take any steps to identify who the other perpetrator might have been, if not your client?
Just so you know, JK, if you say yes, I get money. But if you say no, after your last statement, don't borrow money from criminals, and you say no, I'm just going to think you're a criminal. And I'm going to tell everybody that too. JK is a criminal. Criminally criminal. So how are you going to answer that question, JK?
Sir, other than knowing full well that based on the victims, and I'm going to include the children because they were victims, but based on the victims' identification, it did not match Mr. Gomez. And so we did not have an alibi other than Mr. Gomez was home with his wife.
No, I'm not related, so JK is probably not a criminal.
It was going to have to be a straight up identification case.
I understand. Your Honor, that's what I needed from Mr. Chopra. I'm happy to pass him to Mr. Daniels.
Mr. Daniels, do you have any cross-examination?
Yes, Your Honor.
You may proceed.
Mr. Chopra, you had conversations with Mr. Gomez and obviously in preparing for trial?
Yes, sir. Yes, sir.
And at no point in time he identified this brother up until this 11th hour?
No, sir, I cannot say. Sir, and again, I don't want to mislead you. I don't believe he identified him by name. He might have identified him like in some amorphic structure. Hey, it wasn't me. It was this other guy that had been at the house. I'm not trying to be mealy-mouthed. I always knew that Mr. Gomez had not done it, but I did not know who had done it, if that helps answer that.
Sure. Based on the call that you were privy to on the eve of trial or during trial, would the person who allegedly actually committed the crime be someone who was known to Mr. Gomez?
Yeah, I believe so, sir.
Okay. That's all I have.
And can I expound on that or?
Sure.
I did reach out to the gang unit. Again, I've done this in Cobb County my whole career. I know everybody. I communicated, I think the prosecuting attorney was Henry Thompson, who's now a sitting Superior Court judge here. We had a very long discussion about it. I dragged in the gang unit coordinator for the Cobb County Police. I gave them that information as well. I asked them if they would be able to help me like with a photograph or something of that nature. And I'm not faulting them, but that information was not forthcoming. We were literally on trial.
Okay, that's all I have. Thank you.
Anything on redirect,
Thank you, sir.
Mr. Bullard?
No, sir. May Mr. Chopra be excused?
He's excused. Mr. Daniels,
No objection.
he's excused. Thank you for your time.
Judge, thank you very much.
All right, Mr. Bullard, you call your next witness. Who you want?
I'd like to call Ms. Nadler back, Your Honor, if you give me 1 second to get her on the phone, and I will, if you'll let me mute myself, I'll call her.
We always want you to mute yourself, lawyer. Always. Judge is eating in court and chewing in the microphone. That's good for them, though. He's not going to be cranky. I don't actually know that, because it's so tiny, but that's what I think is going on. Judge is eating. He looks like he would be a long chewer. Chews for a while. Chew, 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 chew. Renting them. I love that. Rent a date.
Your Honor, Ms. Nadler will be right with us.
Now every time someone coughs in court, I think of that other judge who gave the juror a
All right, very
candy.
good. Ms. Nadler, I remind you, you have been sworn. You may proceed with your direct examination, Mr. Bullard.
Thank you, Your Honor. Ms. Nadler, would you state and spell your name for the record, please?
Sorry, I couldn't hear you because I had the volume.
It's all right. Excuse me. Would you state and spell your name for the record, please?
Absolutely. Raina Nadler, R-A-I-N-A-N-A-D-L-E-R.
All right, and Ms. Nadler, are you a barred attorney in the state of Georgia?
I am.
And how long have you been so barred?
2001.
And could you give us an overview of the nature of your practice from 2001 to now?
Yes. For 2 years, I was a traffic court public defender. For 2 years, I worked for the Attorney General's office doing habeas. After that, I worked for the Cobb County Circuit Defender's Office part-time. I led a guardianship program since 2015. I think this is the only case I continue to work on, pretty much criminal. I have transitioned to guardianship, probate, estate planning, and I do only that since, as I said, aside from finishing off this case.
All right. So I guess do you know about when you took this case?
I don't remember exactly. I know it was on after the motion for new trial had been filed by, Mr. Chopra, I call him BC. So yeah, after that, I was appointed by the Circuit Defender's Office. At that point, I was handling, I don't think all of their appeals at that point, but a vast majority of their appeals.
Okay. And could you give us a sense of when you took on Mr. Gomez's case, how many appellate matters that you had handled, just roughly?
From both ways?
Sure, both ways. Yeah.
50, 100?
No, I understand. I don't know. I can't tell you mine either. So, in any event, could you give us a sense of when you take on, or at the time that you were taking on criminal matters for appeal, what your process was, how you approached it, and sort of, not this case in particular, but generally what your practice with regards to appeals in state court in Georgia were.
My practice, sorry. My practice, my practice would be that I would find out if there was a transcript. If there was not a transcript, I would order the transcript. I would meet with my client, usually over a video if I couldn't bring them in. I would talk to trial counsel, and after I had, one addition, I forgot. I also worked for the Conflict Defender's Office doing appeals for Fulton County. I didn't want someone to say, you had other cases.
That's fine.
So, and theirs were a little different than Cobb's. Cobb was easier to get to the court reporters. I would let my client by letter know what I had found and what issues I thought were the strongest. And then I would file a new motion for new trial with the detailed issues that I thought were strongest. And then there would be a hearing, and that's the general process.
Sure. All right. And I guess, did you go through that process with Mr. Gomez's case?
I did. It was a little slightly different because his case was parallel with Mr. Salgado's case, and Mr. Salgado already had counsel involved. And so we were kind of working in tandem in some parts. And so some of the discussions would be, here's what I think, here's what you think, and we would pull together. And then his court-appointed counsel switched. He switched to Mr. Harbin, and so I worked with him. With Mr. Gomez, I filed the motion for new trial. It was a case where I actually requested expert fees, which I did not normally do. I asked for an investigator. If I remember correctly, the judge said that the DA's office should investigate and would get back to me, which was not what I was asking for. We met with the DA's office multiple times. I felt that there was clearly new evidence that Mr. Gomez didn't have these witnesses either available or know about these witnesses. And Eddie Compensano, who was a gang detective, had a CI. And so I really wanted to find out the CI.
Ms. Nadler, let me, we're diving into a lot, so let me break this up a little. No, it's okay, but let me break this up a little. All right, so generally with we're talking generally about your approach to the case. Now let's talk about, so you mentioned you asked for fees to hire an expert. What was your reason for hiring an expert or asking to hire an expert?
We wanted an investigator to investigate. There was the CI. We wanted an investigator to try to, I don't want to say collect the CI, get information from the CI and have a conversation with them and see what information they had. And because it was a gang issue, that was not something I was going to go out and investigate myself.
I understand. All right. So could you give us a sense of how it was that you came to think that there was a CI, a confidential informant, who might have information in this case?
Eddie Compensano, Detective Compensano, he got in touch with, I can't remember whether, I'll be honest with you, it was many years ago. I can't remember whether it was myself or Carter Clayton, who was Representative Salgado, and let us know that he had talked to this confidential informant, and it was after trial, and that the confidential informant might have some very clear evidence that Mr. Gomez and Mr. Salgado were not involved.
All right. Did you have a sense of what that evidence was?
Yes. Do you want me to
go ahead, please?
Okay.
Please.
Just want to make sure.
That's all right.
Our understanding was that the CI was involved in one of the two robberies, that not in the house, but involved, and that when Eddie Campuzano, because he was a CI, showed him the pictures of Mr. Gomez and Mr. Salgado, he said, "Who are these guys?" And he said, "What do you mean, who are these guys?" And he said, "They weren't involved in this burglary. They have the wrong guys."
And once you received that information, what did you seek to do with it?
That's part of when I looked at trying to get an investigator. I wanted to bolster that. Obviously, having Eddie, I don't know how to say this, having someone on the side that should be saying, "Let's get convictions." Eddie Campuzano saying that that he felt there was a mistake, that he thought his CI could exonerate. I felt like we had a very good case. And so I asked for the investigator. We did a lot of, we did some research. I also filed, again, I don't know whether Mr. Harbin or I did this, but I also filed a motion to seal the courtroom once I did have information about the CI, to try to have the CI able to come into court, present testimony, and then feel safe.
And what was the result of that motion?
Yeah, I can't remember if he sealed the courtroom or not. I believe I can't remember if the judge did. What I do remember is that the CI was talked to. As I said, what happened was the judge wanted the DA's office to do further investigation. The DA's office basically said, "We don't think this is strong enough for a new trial." We asked to question him. I know the main issue was when he got on the stand, he was testifying. The DA's office all of a sudden started talking about his rights, and the judge stopped him from testifying and had a different court-appointed attorney have time to go back and talk to him about what he was going to present.
All right. And what happened after that?
The CI didn't present anything.
Okay. And did the CI invoke his?
Yes, he invoked his Fifth Amendment.
Okay.
The attorney had said to him, stop, but then we decided that we would try to get it in through Eddie Campuzano.
All right. And how did you go about doing, or I guess, let me get into some specifics here. Did you attempt to question the CI further once he invoked his privilege against self-incrimination?
I don't have the trial.
It's okay.
The counsel. I don't remember. I do remember that he invoked. I remember it was another circuit defender. So we might have asked a couple of questions, but I don't remember.
All right. All right. And all right. Okay. So do you recall whether you asked him specifically about the misidentifications and his basis for them, regardless of whether he answered? Do you recall whether you asked?
I don't. I could try to find the transcript. I don't have it, but
okay.
Actually I said that I don't have the transcript.
And I know we'll introduce the transcript later. It'll resolve that issue.
The other issue, Mr. Buller, just so you and the judge understands, because Mr. Harbin and I, again, joined, I also don't remember who was asking who, I don't know if the CI was Charlie's. I believe I was supposed to question, or I questioned Eddie, but I'm not even sure about that. So we sort of took turns in terms of the main questions.
Mm-hmm. All right. So I'm going to move on to after the CI invoked and you couldn't get the information you were after from him. You said you questioned Detective Campuzano.
Correct.
So how did you, well, I guess first, what information did you seek to elicit from Detective Campuzano?
The testimony that the CI would have given, that, you know, he saw the pictures, that he was part of the, well, that he was part of the first gang, I think it was the first robbery, that, you know, that he didn't know who they were, that they weren't involved. I'm not sure if I'm supposed to, if I'm supposed to say this. And I don't know if Eddie Campuzano will tell you this, but he had a relationship with the court. So I felt that his testimony would be, if we could get past, you know, hearsay and all that, his testimony would be believed even if the CI didn't testify.
All right. So let me ask, what arguments was there a hearsay objection?
Yes.
All right. And what arguments did you make in support of admitting Detective Campuzano's testimony?
I haven't done criminal law so long, and this case is really old.
It's okay.
Yeah, I don't actually remember that. I know it came up, we brought it up again on appeal when I went to the Court of Appeals, but I don't remember that specifically, what we specifically argued in the courtroom.
Okay. All right. And if there had been an argument, had been a basis for admitting, or I guess, what was the trial court's ruling, if you recall, on the hearsay objection?
I did go back and look at the Court of Appeals and the order and some of the previous documents. I remember he ruled against us on the hearsay. My memory is he let us present it all and took it under, like, we got through the testimony, but he ruled against us.
All right. And do you recall the basis for his ruling against you?
Hearsay.
Okay. All right. Now, do you recall what issues you raised on appeal?
We raised a jury trial. I mean, is it okay if I have that with me?
I have no objection to your refreshing your recollection with it as long as Mr. Daniels doesn't.
No objection.
Thank you. Thank you. Thank you. Thank you. I know, because I already know we raised a jury issue. We raised the newly discovered evidence issue. And in there, we talked about the hearsay issue and the testimony. And we raised, I don't remember what jury issue, but there was erroneous instructions we felt were given during deliberations. I think there was 2 different erroneous instructions based on jury questions.
Understood. All right. Do you recall what arguments you made in support of the Superior Court's or the trial court's the trial court should have considered the hearsay testimony?
Give me a minute. I don't remember what we said.
She's looking for something. We can't hear her because she's not talking. We're not missing anything.
Not finding it, and I don't actually remember.
It's all right. I think we'll introduce that too. It's point. All right. If there had been, okay, Ms. Nadler, if there had been an argument that would have justified the admission of the hearsay and the trial court's considering it, is there a reason you would not have made it?
No.
Okay. Now, did you ever consider asking that perhaps moving that the CI be given use immunity for his testimony, given how central it was to your claims?
would have thought we did. I don't actually, again, I don't remember doing that. If I remember correctly, and this could be incorrectly remembering it, he was, that robbery and some of the other things had gotten him to a CI, so we didn't feel like he was in he was in the community, he was working, he wasn't part of a gang, and we all felt like he was, our side felt like he was not going to be prosecuted or gone after in any way. So I know for a fact that we were, I don't want to say angry is the right word, angered by the fact that the DA knew all along where we were going and waited till the CI was on the stand to all of a sudden bring up that he might have a reason to plead the fifth. Because we had been talking to the DAs, for months. And so for them to all of a sudden go, oh, wait, he needs to be protected when he's already on the stand seemed very disingenuous.
I understand. And subsequent to that, did you consider moving for use immunity for his testimony?
That sounds familiar, but I really don't remember.
All right. And if you had not, would there have been any reason not to?
No, we should have if we didn't.
Okay. Your Honor, I think that's all I have from Ms. Nadler at the moment. May I have a moment?
Examination, Mr. Daniels.
Yes, Your Honor. Ms. Nadler, can you walk me through what your normal process was when you were assigned an appeal in terms of preparing and identifying issues to raise?
I would obviously ask my client what issues he felt were there. I felt that was right to do. I would talk to the trial attorney, and I would comb the transcript.
And is that generally what you believe you did in Mr. Gomez's case?
No, I definitely did. And as I said, this was an unusual situation because Salgado's attorney also was doing the same thing. So I had two of us.
And with respect to the issues that you did raise on appeal or in the motion for new trial and on appeal, were those the issues that you believed had the most likelihood of success?
I think they should have succeeded. So yes. So yeah, those were the issues I thought were the best issues.
And do you recall whether or not, when you were at the motion for new trial stage, if there was some discussion by the state with the confidential informant that he may be subject to prosecution in other jurisdictions for things unrelated to the armed robberies here?
I do, but not until we got the CI on the stand.
That's all the questions I have, Judge.
Anything on redirect, Mr. Bullard?
Two things, Your Honor. Ms. Nadler, in your arguments to the Court of Appeals, do you recall whether you focused on the trial court's rejection of the newly discovered evidence claim generally, or on specifically whether it had abused its discretion in excluding the hearsay testimony from its consideration?
I think we focused on both. I know we said something, we definitely brought up the hearsay because that was sort of the crux. But yes, I think we raised both because Timberlake, one of our arguments I know was on Timberlake, and I remember this, I saw it, but I remember it, was that motion for new trial was different than an extraordinary motion for new trial. And so we tried a legal-based argument on that side related to Timberlake.
Okay. And second question, When you lost to the Court of Appeals, did you petition for a writ of certiorari?
Absolutely, which was not my normal procedure.
Okay. Thank you.
Anything on?
That's all I have, Your Honor.
Anything on recross, Mr. Daniels?
No, Your Honor.
All right, Mr. Bullard, you can call your next witness.
All right, may Ms. Nadler be excused, Your Honor?
Is she free to go?
She is from the petitioner, Your Honor.
Yes, Your Honor.
All right, very good. Thank you for your time, ma'am.
Thank you.
All right. Petitioner calls Eddie Campuzano.
Mr. Campuzano,
He can still hear us. I may have to call him as well, Your Honor. So if you give me one moment, I can get him on the phone.
Is it just me, or does the
Your Honor,
judge
Detective Campuzano will be right with us.
move at a swifter pace when it's attorneys? They're barely done saying no further questions, and he's already talking.
I'll remind you that you're under oath, okay? You may begin your direct examination, Mr. Bullard.
Thank you, Your Honor. Could you state and spell your name for the record, please?
It's Edward Campuzano, EDWARD, CAMPUZANO.
And how are you employed?
Currently, retired from COPD, but as a reserve now, so I've been doing that since 2015. So currently still with the county.
And how long have you, or I guess, how long have you been in law enforcement?
Started in 1984, New York City Transit Police. Moved down here in 87 and been with cops since then.
And what's your rank?
Corporal at the time I retired.
Okay. And I guess what was your role? Did you hold any? I always mess this up. Did you hold any other titles with the police department?
The one time when I was working with the gang unit, we were, I guess, classified as investigators, not, so we're gang investigators.
Okay. All right. So, in the course of your work with the Cobb Police Department, did you ever? Let me back up. Are you familiar with the robbery case that the petitioner Marco Gomez was tried and or was prosecuted and convicted in?
Yeah, I was made aware of it. Yeah, I'm familiar with it. Yes.
All right. How did you become aware of it?
It was through my supervisor, who another supervisor was talking with a gentleman named Alex Gomez, who ran a tattoo shop in Kennesaw. So apparently this supervisor heard a story about a friend that was arrested and was charged with a home invasion, and felt like the gang unit should be made aware of it. So he notifies my supervisor, and he tells me, hey, I need you to go check into this information about a home invasion that occurred. And so he kind of gives me a little bit of the activity that happened, what was done. And I tell him, I said, well, wait a minute. I said, that sounds like the CI that is currently right now with me and with the FBI Gang Task Force, because I was assigned to that too. And I said, when this particular CI of mine was arrested by Cobb County on a separate charge for driving without a license or whatever, and I spoke with him in jail. I said, well, in order for me to help you to get out of jail, you'd have to give me something that I could give to the FBI, and they could probably give you, like a confident informant status and all that stuff, and you could help me. So he tells me the story about him being involved in a crew in a home invasion, and he was only brought on because the original crew, one of the crew members had been arrested, and he wasn't there, so since he was close with a lot of these guys that I've known since juveniles and stuff like that, and now they're adults, he said that they asked him to come out to this particular home invasion, and that he would be the lookout, basically. So that's how he tells me the story. And I asked him, I said, well, do you know of any reports being made or anything? And he's like, nah, this is one of those home invasions that's done on local Paisa, the way they would refer to it, and say they're not gonna make any reports about it and all that stuff. So that's what got him in the door. That's how he became my CI. And he was also somebody I've known since he was like 14, 15 years old as a juvenile in the area. So we had established a good friendship, him and his family, his mom, who really was involved with him getting out off probation and all that stuff. And so anyway, I think I'm just rattling on.
No, it's fine. So I guess, did you ever have the opportunity to inquire of your CI about Mr. Gomez's involvement in this armed robbery?
Only after I get the information about all this stuff and I start kind of looking into it, right away, and I can't remember all the details, but I was able to pull up and again, just for the judge to understand, or, Cobb County has city municipalities within the county, and apparently this particular incident happened in the city of Marietta. So it involved just city of Marietta detectives, and I think they had a small unit that was dedicated to handling gangs and all that stuff. So like I said, now the information that's coming to me is outside of that jurisdiction. So we wouldn't have never had any kind of a way of knowing what had happened there. So when I do look into it a little bit and I find out that these two people, and I'm almost sure I even went to Alex Gomez's business, and he gave me the name of his friend and the people that were charged with it. So I pull up their booking photos and take their booking photos to where my CI was working outside of Cobb County. He was working in Fulton County at a restaurant. So when I have this meeting with him, and I also have our criminal analyst with me to just to be a witness there, and I ask him about the incident again, and he tells me again who is all involved, and then I show him the two pictures of the book-in photos of these two particular people, and one of them is Marcos. And I said, well, who are these guys? And he looks at them and he's like, I have no idea. And I was like, are you sure? And he's like, definitely. And I was like, well, these two guys were charged with the home invasion that you were telling me no report was ever made. And so I said, I just need to keep you, he wasn't a right flight risk of any sort. So with all that being said and done, I just did follow up a little bit more. I did find out who the detective for Marietta was that had put the case together. So by the time I got involved and caught up with the detective in Marietta, he
could you tell us who that was? I'm sorry to cut you off. Could you tell us who the detective in Marietta was?
I think it was Detective Shane Merritt was his name. And so by the time I caught up with him and caught up with everything, the trial had been over. The two gentlemen had been already convicted, so I was like really at the tail end of everything. So I did have 2 meetings with Detective Merritt on the side, just friend to friend, cop to cop, whatever you want to, sorry, whichever way you want to look into it. And I told him, I said, hey, I got somebody, a CI, that could identify the actual crew that was involved. The only thing is that my CI was part of it, but he's willing to testify and all that stuff. And I don't know if anybody wants to hear what his answer was, but if his answer was anything other than what he gave me, we wouldn't all be here at this meeting right now. But he was satisfied with the way the trial turned out, and he was not going to do anything outside of that.
After speaking to Detective Merritt, did you do anything else with the information from your CI?
No, that was it. Like I said, Shane Merritt held he held the key to reopening up the case, or, trying to at least, do his part in saying, well, if we have information about who these other people are, and I think I was able to find 2 or 3 out of them. 1 or 2 of them had been scheduled to be deported and all that stuff on a separate charge. So I found him in ICE custody at the time, and he basically said, "Yeah, what about it? It doesn't matter. I'm out of here." So so I did find the crew for the most part, but the 1 or 2, one other one was still in the Cobb area. But like I said, it was not my case. It wasn't our case. It was a city case, and all we could do would offer our assistance with it and all that stuff. But the detective did not want to reopen that case.
All right. Did you ever reach out to the district attorney's office about it?
So am I hearing this right? Every single body, everybody knew he was innocent? He's in jail?
No, I didn't think that it was, everything was going to be determined on the detective. The detective would have to be the one that initiated the investigation. It would be on him, not so much me. I don't, so, yeah.
No, I understand.
Yeah.
And did you ever speak with Mr. Gomez's appellate lawyer about this information?
I know I was, I guess, subpoenaed or brought in on 2 attempts of an appeal and all that stuff.
I have to ask because I'm struggling to know right now. I'll ask JK because JK will know. I have 47 people watching right now and 0 people chatting right now. JK, are people watching the video? Are there people who are watching the court case?
Her name kind of, I remember one time.
Would it have been Ms. Nadler?
Could have been, yeah. I know there's a female attorney there, and she represented Marcos at the time, and and it was the same thing. I was bringing the same information to her about it. And so, I was just there to provide any assistance I could with the CI. I brought the CI with me, so.
Okay. All right. All right. And did you end up testifying at the motion for new trial hearing?
I believe it testified again about how I became involved in it on a peripheral, and I brought the CI, and I don't know exactly what had transpired there, but at one time, the CI was in an isolation kind of room and all that stuff. And when I got done talking about my part of the case, or who I, explained to the judge who I was and all that stuff, and I find, I guess the ADA would be Mike Carlson at the time, and his investigator, Charlie Lida, in there, who I've both known, for a long time in the gang unit kind of stuff. And apparently my CI was kind of shaken up because he asked me to step outside, and I did. And he was basically saying that they were kind of intimidating him, saying that if he was to testify, that they would probably charge him with it because, since he was involved in all that stuff. And I kind of got a little upset with them, saying, he's here on good faith and he's going to testify. He's trying to help. And I got the feeling like they were trying to protect the case, protect the detective, didn't want to open up another can of worms, in a sense, and all that stuff. So after that, I was kind of, like I said, shocked about the way that this particular aide, Mike Carlson, was behaving towards the whole CI, towards the whole case.
Yeah. All right. You mentioned a little bit ago that you had tracked down whom you believed to be the actual crew, based on what you're seeing.
Thank you, Zach. Thank you.
Did you, when you were doing this work, happen to have the physical descriptions that were testified to at trial or from the original reports of the robbers, the mass robbers who did the work?
No, no. I was going solely based on the name that the CI had provided, because he knew them by street
Hi, Patty.
name and somewhat real names and all that stuff. So that's how I collected that information. I didn't, like I said, I didn't really read the case because it's a Marietta case, so I didn't have access to that. So, but Detective Merritt, when we did meet, we did exchange that information. He had the names of the people that were involved in all that stuff, and he decided not to do anything with it, obviously, yeah.
I understand. All right. So, Investigator Campuzano, that's all I have. Thank you for being here this morning. I'm sure Mr. Daniels has some questions for you.
I cheated and looked. We have about 20 some more minutes.
Tell me about SIR 13. What is it?
It's a Serenia gang out of California, mainly south of Bakersfield, being the drawing line in California. So it's a nationwide, nationally known gang, and the ones that I dealt with in Cobb County at first did not have direct ties to them, but eventually SIR 13 did bring in some representatives where they were required to pay dues and stuff like that. And I can tell you that from experience, a couple of people that I know that were claiming SIR 13 got in trouble when they did meet up with actual SIR 13 gang members in the area. So
SIR 13 have, like many gangs, have a code of silence?
They have that code of silence, but they have, we wouldn't know anything about SIR 13 if there weren't any weak links or people willing to, give up that code of silence to be able to try to live a normal life. And there have been gang members of SIR 13 that have, wanted to get out of the gang and all that stuff. So that's like anything else. There's always a weak links within the gang.
And the victims of this home invasion, the Munoz family, you had described that it was sort of a typical type of robbery that members of the SIR 13 would have committed. Can you expound upon that?
I was not familiar with the family or their habits, whatever whatever business they conducted. The only explanation or the only description I got of that family was through the CI saying that the dad did have money and he was the one who would deal with either gang members or anybody at the time. So, but apparently the gang members, and not all, some of them that were in the crew were just, one was maybe SIR 13, the other one was LNS, I think was an LNS member. And so it was like a combination with that. So that was the only description that I got of the homeowner, not so much the family, the nucleus who was there, wife, kids, or whatever, but just the male in the house was the one that the crew was familiar with. And I don't know what capacity they were familiar with about money or whatever, but somehow they knew, because this was the second attempt that they went there, because the first time turned up nothing, according to the CI, even though he was not part of the original robbery, the first robbery. But the second time it was, and that's where they got money or stuff like that, according to the report.
In your experience, was it typical for a SIR 13 crew to use other gang members or non-gang members as part of the crew?
Yeah, like I said, California and other places that had established that type of gang, yeah, it's more tight-knit group, but George
Thank you, Zach. Thank you. Hi, Walter.
Cobb, even talking with other gang investigators, throughout the metro area, as long as they claim under the umbrella of SIR 13, LNS, anybody that claimed 13 other than, Northsiders, Latin Kings and stuff like that, yeah, they all kind of got along because most of them all went to school together. Most of them got on the same school bus, and, it was just a preference. And so, yeah, for him to tell me, so-and-so was there, he SIR 13, so-and-so, LNS, and, it wasn't an unusual thing to say because they all hung out together.
In your experience, was it common for SIR 13 crews to hit a house of someone they knew?
On a retaliation, probably, but on this particular one with money being involved, this was kind of a new thing. That was for me, my experience, that was the first one I've heard of like that.
And you alluded to before that I think the CI told you it wasn't one that would have been reported. What would have been a reason it wouldn't have been reported?
I don't know. That was his opinion. I didn't really ask him. I don't know if there was any, I guess, for them to wear a mask, it would give me the impression that one or two of those people have dealt with this particular person, because how would they have known what this particular person had in his house and all that stuff. So yeah, like I said, it wasn't my investigation. I'm just going based on that one or two of these guys were heavily tatted and easy identifiers and all that stuff. So, but somehow one of them, two of them knew what was going on at that house, or they wouldn't have hit it. Because if it's in a trailer park, they hit the jackpot on their first try if they were just pick a trailer and let's get some money out of there. So apparently there was some previous knowledge about what was going on there.
Did Detective Merritt ever tell you that two of the victims identified Mr. Gomez?
No, he never went into details about anything about how all that came about. And the only thing that I did through my investigation, one of the members of the crew, the robbing crew, was Mr. Gomez's brother-in-law. And I had a warrant out for him too, but it was just kind of an unusual, like I said, all this was not to reopen the case, whatever. It was just for my, knowledge about what was going on. But, but I can tell you right now that Gomez's wife at the time was really tight-lipped about giving up any information, especially that it involved her brother and all that stuff. So, but that's, that's where it went as far as that part of the case.
If you were investigating a case and you had two victims who positively identified somebody, that'd be pretty compelling evidence, right?
Well, yeah, if positively identifying them, through the lineup sheet, yes. But from what I'm understanding, this was all based on a tattoo, maybe one or two tattoos that were identified by some kids at the time, not so much by the adults. I'm not 100% sure about all that. But like I said, a lot of the gang members, SIR 13, Northside, LNS, anybody could have had basically a same tattoo in the same location, so I would have tried to at least try to figure out more about it and, not rely on the testimony of kids for my case.
That's all questions I have.
Anything on redirect, Mr. Bullard?
Investigator Campuzano, I know you said you'd spent several years with the gang unit for the Cobb Police. What, I guess, specialized gang training did you have in the course of that, of that portion of your employment?
At the time, Georgia Public Safety Training Center in Forsyth offered a gang class courses. So I took almost all the gang classes that were offered by the state, by the training center. And then I was part of the GGIA, which was the Georgia Gang Investigators Association. So I would go to their monthly meetings and learn about stuff, learn about other gang members, because gang members, had no boundaries. So some of my guys would end up in Gwinnett or DeKalb County and stuff like that. So I did the most I could. And on top of that, I would get involved with the Cobb County Juvenile Probation Officers that were doing gang suppression programs and try to, see where they were coming from in a middle school age, going into high school, and all the relationships and all the friends that they had as far as gangs. So I was able, with the gang unit, we were able to solve a lot of, runaways, gang graffiti cases based on the rapport that we would build with juvenile probation, especially the gang suppression officers.
Now, I guess, could you give us an estimate of how many gang cases you worked for when you were for Cobb County?
At least 50 plus, if not more. So yeah,
yeah. That's why I asked for an estimate.
Yeah.
So, I guess, and what is the territorial jurisdiction of the Cobb County Police?
Basically, like the boundaries are all together. On the west side, I think it was Douglas and Paulding. On the north side would be Cherokee and Bartow. So that would be kind of, and then on the east side would be another Fulton County.
Don't you start with that north and east and west and south. Don't you start with that. It's head towards McDonald's, head towards Pizza Hut, head towards Turkey Hill. No. Come on now.
Roswell, and then on the south end would be Fulton County again so I worked mainly Smyrna, Marietta area, outside of the city limits, Mableton area and all that stuff. So yeah, a little bit of West Cobb at the time, not so much East Cobb. That was not. So anyway, but yeah, East Cobb was different.
Yeah, fair. All right, but I guess what I'm getting at was, did your jurisdiction cover, your department's jurisdiction cover the entire county?
It did, yes.
And were you familiar in 2006, 2007, or what gangs were active in Cobb County in 2006, 2007?
We had gang members with some hybrid gangs, which would be a combination of gang members that would claim they were Bloods, Crips, or whatever, but they didn't they didn't actually carry that same name. They would be called other names. And then, but on the Hispanic, the Latino gangs and all that stuff, for the most part, they did represent CERT 13. They did represent Northside 14. They did represent LNS, GTO. I think GTO was another one. So a few Latin Kings. So I guess my specialty, or my particular one, was all Hispanic gangs. Some of the other investigators that I work with, their specialty was, the Bloods, the Crips, anything that was not Hispanic.
Okay. And so from that experience, did you become, did you develop the experience to be able to identify members of CERT 13 or other Hispanic gangs by their by either markings or tattoos or any kind of clothing that they wore, anything like that?
Yeah, at the time, they were not shy about wearing their colors and all that stuff. So over the years that they realized that they made themselves targets by wearing that stuff. They started to curb their appearances and all that stuff. But yeah, for the most part, anybody that was on probation I made sure I knew who they were and they knew who I was and got involved with the family. I'm bilingual too, so I was able to talk to the families that didn't know English. And I would always leave them my phone number. So I would say, Junior is acting up and he's on probation. He leaves the house. Just give me a call and I'll get out there and all that stuff. So I did, the unit did a really good job trying to stay focused on the family, and the family helped the community. So if we were able to control that, curb that, in our opinion, that was going to curb a lot of the gang activity in Cobb.
Yeah. And so, and also from the same experience, did you have at least a sense, or not a sense, but did you keep a database or sort of a working list of known gang members?
I kept files in there. Can't really say if we kept the database because of what was going on back then at the time. But we all did keep, files of our own way of knowing, who they were, how they were doing, what's their status and all that stuff. And I kept track of them.
Yeah. So the members of the robbery crew that your CI identified for you and you tracked down, did you have any reason to think that they might have been members of SIR 13?
Yeah, like some one or two of them were. One of them that was deported was it was somebody unknown to me. Mm-hmm. But and then another one I believe was from the Gwinnett County, and I believe he claimed LNS and all that stuff. So I knew who he was. I knew him by name. His name had surfaced on several meetings, but somehow he was able to connect with my guys in the area and all that stuff.
And other than in this case, the one that we've been talking about today, were you familiar with Marco Gomez from any other investigation?
No, I was not.
All right. That's all I have on redirect, Your Honor.
All right, anything on recross, Mr. Daniels?
No, Your Honor.
All right, is this witness excused?
He can be from the petitioner, Your Honor.
Any objection, Mr. Daniels?
No objection.
Thank you for your time, sir. Call your next.
Oh, you're welcome.
Call your next
You're welcome.
witness, Mr. Bolden.
Petitioner rests, Your Honor.
All right, Mr. Daniels, do you have any evidence?
Your Honor, I would tender some documentary evidence. However, Mr. Bullard made a comment earlier that I think he's anticipating me putting the entire trial record in. I can obtain the portions that I am missing because I do not have the complete trial record. I do have the briefs and opinion filed in the Court of Appeals.
Well, you submit what evidence you want to submit, and, if Mr. Bullard's hadn't submitted it, that's on him.
Your Honor, I would submit Respondent's Exhibit A, which is the briefs and opinion filed in A18A0179, the direct appeal in Mr. Gomez's case.
Any objection, Mr. Bullard?
No, Your Honor.
All right, submit it without objection.
He doesn't have the transcripts.
Anything else?
I have nothing further at this time, Your Honor.
All right, anything rebuttal, Mr. Bullard?
Your Honor, since Mr. Daniels, my experience has been that the AG's office has presented the entire trial record.
Mr. Bullard, do you have anything in rebuttal?
Your Honor, I would ask to, no, not in rebuttal. I would only ask to hold the record open so we could get the rest of the trial evidence, or the rest of the trial transcript.
Mr. Bullard, that's, the way I understand the law, that was on you to have present today. I'm not going to hold the record open.
I understand, Your Honor.
This poor guy, he's going to stay in jail now.
Anything further, Mr. Bullard?
No, Your Honor, we just asked for a reasonable time to brief the case after the transcript from this hearing is prepared.
All right, it's my practice that I give you, the petitioner's counsel, 30 days after you receive the transcript in this matter. And then Mr. Daniels will have 15 days to file a response, please. The evidence in this matter is closed, and as soon as you get the transcript, the court will be looking for your brief within 30 days. All right?
Yes, Your Honor.
Very good.
Oh,
All right, that'll
man.
conclude this matter.
Holy cow. Oh, can you believe that? Oh my gosh. Oh my, so this guy did not commit the burglary. Everybody knew he did not commit the burglary. They had someone on the stand during the trial to say, hey, yeah, this guy really did not commit this burglary. But he couldn't testify. He took the fifth. He's a confidential informant. So he couldn't testify because he would go to jail for his parts. So then they get to the appeals, 2 different appeals. Everybody knows this guy did not commit this burglary. 2 different appeals. He lost. I don't know why. I tried to figure it out from this case, but I don't know why. All this lawyer had to do was provide transcripts of the appeals. And he didn't. He expected someone else to do it. Look, I'm not a lawyer and I don't know a lot. I do know that if you want the judge to look at a piece of evidence, you have to provide it. I know that. I know you can't just expect someone else to have it ready. I mean, that has to be Lawyer 101. It has to be taught in like first year law school. If you would like evidence to be provided to the judge, you must provide it. That's you. It doesn't matter if you're prosecution or defense. Oh my gosh, this guy's gonna lose. This guy's gonna lose this habeas. He doesn't get another shot at habeas. You can't have 2 habeases, right? Because of poor representation of counsel. And it's worse than that. Oh my God, it's so much worse than that. Because he's not just in jail. He's in Georgia. Oh God. Oh, that just turned terrible in the last minute. He can't get a retrial for habeas. You don't get as many habeases as you want. Oh my gosh. Oh my gosh. Oh, that was horrible. Oh, that was just so bad. I wish I never would have seen this. I wish I never ever would have seen this case. He's not even a gang member. Well, he's a gang member now. He's been in jail for 7, 11, 4, how many years? I don't know. I didn't pay attention to how long ago this was. But so yeah, he's definitely in a gang now. It's the only way to survive in Georgia jail. Oof. 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 What a train wreck. Alright guys. Although our judge, he was very quick today, wasn't he? It was very, very quick. Yeah, he might rot in there. He absolutely might. Oof. Geez, that's not fair. It's just not fair. It's just so much in Georgia is just not fair. I just don't see how they keep doing it. Anyway, I'm going to start OJ now. I hope you guys have a great, great, great Saturday. And I will see you all again tomorrow. Unless Bill streams tonight and I'm awake. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,